Stephen Breyer was appointed on August 3, 1994, by President Bill Clinton. Clinton considered Breyer the year before, but ultimately lost the spot to Justice Ruth Bader Ginsburg before being chosen the following year. Breyer is known as the most pragmatic justice serving on the bench. He takes a practical approach to assessing a law's constitutionality by looking at the consequences and purposes of the Constitution's text, rather than looking at the text in a more literal and historical fashion. He has been known to work very closely on many cases involving the First Amendment in regards to his constitutional interpretation. Breyer has openly criticized originalist methods of approaching the Constitution. He has spoken with Justice Anton Scalia in the past regarding his stance. Scalia described the approach of the evolutionists versus that of the originalists. If you're asking about fundamental method of interpretation, I think you're asking about the major division, not just between the justices on the court, but in American jurisprudence generally. That is, there are those who think the Constitution is to be interpreted in such a way as to keep it up to date. That is to say, it does not mean today what it meant when it was adopted. Some of its provisions change in order to keep up with the times. My friend Justice Breyer has that view. Breyer wrote Active Liberty to explain his judicial philosophy of interpreting the Constitution, including criticism of originalist or textualist methods as a primary method for approaching difficult constitutional questions. In the book, he encourages citizens to increase their understanding of the Constitution. Regarding his opinion on the application of the Constitution, I think we're following an intention by people who wrote this document: Madison, Adams, Washington, and Hamilton. They had an idea that they were writing a constitution, and in that constitution, they would create certain institutions to create basically democratic systems of government protecting basic liberty. And what they intended with these very basic values in a document would last for hundreds of years. So they had values that changed but little, while the application of those values changes as circumstances change.
In the 2015 case of Overfell v. Hodges is an example of his interpretation of the Constitution as a living document. The court declared same-sex marriage constitutional under the 14th Amendment because marriage is a fundamental human liberty that can not be denied on the basis of sex. On Breyer's most famous dissent, Glossop v. Gross, it dealt with the constitutionality of Oklahoma's lethal injection process. In his dissent, Breyer stated that the constitutionality of a punishment must be evaluated based on currently prevailing social and legal standards. Breyer makes his decisions based on an active constitution, but also on precedent of past laws. An example of this is Sternberg v. Carhart, which ruled a Nebraska law banning partial abortions was unconstitutional as it interfered too heavily with a woman's right to decide her own abortion. He stated it also violated Roe v. Wade, which is like an established law. Based on stare decisis, Breyer dissented on the monumental case of Citizens United versus the Federal Election Commission, siding with what they considered to be free speech of individuals over those of corporations. Breyer's protection of public free speech against corporation was also reflected in his dissent in the case Eldridge v. Ashcroft. In sum, Justice Breyer is for the living people in the living Constitution. Thank you for watching.